Good morning, everybody. Good morning. Well, he here today. This is day 3 of the trial. The actual trial itself has moved pretty fast, guys. I can't believe it that it moved that fast. But under the circumstances of Sarah Boone, with her tactics and all this trickery going on, and the motions filed, I think the state had to change their strategy. They had to change it, and it was a little bit hard for them, I think, because they had to watch what they say, because they didn't want to open the door. And this is why the witnesses from the state, when they questioned them, the state and the defense, it was only a few questions because they didn't want to open the door, I think. And so this is why some information, well, maybe a lot, didn't come in from the state now. So today is the day we've all been longing for. But it might not go the way we wanted it to go, because Sarah Boone is going to take the stand around 10:30 this morning. Now, is she going to do it by narrative? We'll have to wait and see, because yesterday was a bit of a rough day for her, and she had to sit there through all the videotapes and the interrogation. And after a very long day, which went on for an extra hour, an hour more, it went till 6 p.m. Eastern time, because they wanted to finish up on the interrogation tapes at the office, and then after that, the state said that they were going to rest. They're not going to call anybody, and it's like a shocker to the defense. They're talking about a witness coming in who's gladly volunteering his services for free, but he wants to do it by Zoom. And they go, whoa, wait a minute. Null them reigns in a little bit. And I found that odd. I'm like, wait a minute. We're in a murder trial here. Why want to do it over Zoom? It looks like they're coming in right now, so let's go ahead and go into this right now.
Case number 2020 CF 260, the state of Florida versus Sarah Boone. Announce your names for the record, beginning with the state.
Dave Ketchner on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Ma'am, good morning. Can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a black blazer and a dark blue blouse. She is in custody. However, she is not in any restraints, so we will continue to stand while the jury panel enters and exits. My understanding is that our panel is here this morning. State, do we have any housekeeping matters we need to address before we bring back in our panel?
Yes, sir. 3 discovery issues, and then I filed a motion late last night requesting an in-camera inquiry into a potential conflict of interest. I copied your JA.
I did review the motion.
Okay. The 3 discovery issues are these. One, on October 5th or October 4th, I believe the defense was provided with the body-worn camera 911 calls from the prior incidents, and there was a request made to tell us what, if anything, should be redacted from their point of view, so that we could either reach an agreement or use the court's resources to decide any conflicts in those issues. Yesterday morning was the first actual response I got from the defense team, and it was incomplete. It was about 3 of the 5 incidents. I do agree with 2 of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court's screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The 3rd incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the 4th and 5th incident. I was told that Attorney Beck was going to handle it. It is now Tuesday, day 7 of trial, and he has not handled it. The second discovery issue is Friday, I was given a hard copy of the 119 pages of the second copy of the Winter Park Advent Health
On
records.
10/18, October 18th? That would have been the
Friday.
preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, which is pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended exhibit as it shall be introduced into court, so I can confirm those things ahead of time and not in court. And then the third thing is, I believe we had a discussion about the plethora of pages regarding the victims' hospital records, and that there was some sort of discussion we had that they were to narrow it down. And I have not been given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
Okay. Responses to the first discovery issue regarding body-worn camera and 911 calls is to the, my understanding, 5 prior incidents. Defense.
Judge, I can speak to 3 of them. There were 3 of them that I reviewed, and I believe I reviewed them on Sunday. I had made the decision for what I thought needed to be redacted. I think the first 2, if I remember correctly, I said that was fine. We didn't even have any redactions to it. I think it's 1 that I said redactions to, and I think the state agrees with that. The specific one that I didn't quite know, and I think that has to do with a body cam where it comes to, and I believe it's Mr. Torres's mother. I can't quite be for sure, but she's been asking questions and all, and I think it's about, if I can recall correctly, about Mr. Torres's whereabouts at that time. I didn't know the relevance of that at that time, but that was the only part of that to let the state know. I just don't really know the relevance. It could come in at a different point and become relevant. But as to the other 2, I think we were on page with. I had been out to the jail that day. It was late. Then I asked Mr. Beck to do the other 2 redactions, but I hadn't had the opportunity to talk to him about that since, so that's where we are.
So is the 3rd incident that the state has identified for which there's no seemingly no responses to redaction, is that the body-worn camera purportedly between law enforcement and Mr. Torres's mother?
That's what I believe it to be.
Mr. J?
Bless you. We're just not on the same page. On that 3rd incident, which I believe was June 15th of 2019, the state only indicated to them that we were intending to introduce 1 video file. It is not of the victim's mother. It is of them at Sarah Boone's house. And the objection to the files that they were objecting to, which we don't seek to introduce, just said ID. And I don't know that as a legally recognized objection. So I'm confused, I'm not sure, I'm just trying to make sure we're all on the same page. We understand which file the state wants to use regarding that third incident, because he's describing files the state does not intend to use. The first couple of incidents, we agree, there's a 911 call that seemingly cuts off into an OPD call at 3 minutes and 51 seconds. We're cutting that to the end. The second one, Ms. Boone at like 3 minutes and 43 seconds indicates that she had been arrested prior. So we cut that out at their, we're going to cut that out at their, that cat's out of the bag. So what we're looking for now is just making sure we're all on the same page about the third incident. I sent screenshots. There's a tool called Snipping Tool in Windows. I literally create a rectangle around the files that I'm intending to use, their file size, and the folder that includes the OCSO agency case number incident, so we could be as crystal clear as possible. And I'm still getting objections about things we don't want to introduce on that incident, and I've gotten no response with the fourth and fifth incidents.
All right, addressing the third incident is the specific portions of the June 15, 2019 incident, seemingly the body-worn camera that you're making reference to, Mr. Henderson, the state has no intention of utilizing.
Yes, sir. And Judge, it's a lot, so if I could have one more.
Sure.
To isolate which incident it is. That's not the one. My understanding is the state is talking about the third incident. That would be June 18th.
Here's the problem. I sent these pictures over with the OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So we can just make the record entirely clear. OCSO incident 18-067501, there was no 911 calls and apparently no objection. So they have no redactions requested for that 2018 case. Then the next response was 6/15/2019 case. And that, for the record, is OCSO 19-054917. Their request on that one was the 911 call that we just discussed, indicating that at 3:51, well, I had to find it, 3:51, it turns into another case, and to redact that to the end. We agreed. Video 3 in that file, again, no file name, indicates at 9:40 to 9:43, there's a redact request with paren previous arrest. The state agrees to that. We heard her quickly say that at 9:43, and we will get that taken care of. Then their next response was 6/18/2019 case, which I had to cross-reference back to show that it is OCSO 19-055572. And in that particular case, what I sent them was a screenshot that includes the OCSO case number 19-055572, and it indicates there is an intent by the state to introduce 2 911 calls and 1 video file labeled axon_flex_2_video_2019-06-18_1330. My response that I received from them was video 3 in file, 2 minutes 7 seconds to 2 minutes 18 seconds paren ID, and then video 4 in file, 2 minutes and 4 seconds to 2 minutes and 16 seconds paren ID. So my confusion lies in I did not indicate 3 or 4 files, it was just 1 file. And then again, with the other 2.
I don't want to address 4 and 5 yet.
Okay.
It's my understanding there's no response. We'll address that momentarily. Responses to the clarification as to what it is the state seeks for incident 3.
No redaction.
Okay, all right. With regard to incidents 4 and 5, Mr. J, could you place on the record what it is specifically as to those incidents the state may be seeking to introduce?
Yes, sir. So what we're calling incident number 4 should be OCSO 19-078009, August 28th, 2019. We indicated the desire to use axon _flex_2_video _2019-08-28_2024. And then, at their request, they had desired to get photos of Ms. Boone's injuries from that case. There is a 19-page PDF file, which has pictures taken by law enforcement of her injuries. I don't see anything else in there. One picture of Mr. Torres, a couple pictures of Mr. Torres, but nothing that the state was objecting to. So that was at their request that they wanted photographs in. So that is incident 4, which is labeled OCSO 19-078009.
With regard to seemingly the body-worn camera that the state seeks to enter into evidence from August 28, 2019, what say the defense?
John, I don't know about the state's position on this. There's a portion of this video at the very end that's very personal to an investigating officer that they may want to redact. We're not asking anything to redact.
Is the state seeking any redactions?
I'm just clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then
So are there any redaction requests with regard to that particular file?
No, Your Honor.
Okay. I'm just keeping notes. Give me a moment, y'all. As to the 5th incident, Mr. J.
No redaction request, Your Honor. I do want to point out that we were apparently advised yesterday that the state was only going to use the 3rd video possibly. And so we haven't really spent a whole lot of time worrying about it since then.
Let me clarify as to what the 5th incident is, just so that we're all on the same playing field.
Judge, the 5th incident is OCSO 19-079759, and that was on September 4th of 2019. Within that screenshot that I sent to them, Friday and then resent it this morning, was photographs of the defendant taken at that time. At their request, shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Strike that. 192473549_GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
Well, we're not necessarily seeking redactions, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres, one seems to focus on Ms. Boone, and there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in the shower for master bath. And so some of that's redundant, but there are actually 2 separate videos pursuant to the 5th.
Mr. J, are there 1 or 2 videos that the state's seeking?
There's the one that I listed, filing for non-important order.
Okay. Do you know if that's Bruce, can you find out what council's here for? Is that the video from the perspective of, as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Mr. Beck, the specific file number was identified. So just to confirm, no redactions? Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are 2 911 calls and 1 body-worn camera sought by the state to which the defense has no redactions. The August 28, 2019 incident for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the 5th event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week, we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday. How that list was culled down and the additional pages that the state was seeking, and then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense, that the state wanted extension out of ruling completeness. I believe we're
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in, those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
I'm not sure it exists, you know, that's what I'm saying.
But if it's going to be moved into evidence, we have is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that if it's an electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages just to confirm it. Lastly, with regard to hospital records of the victim, I know there were conversations and discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital records for the victim, George Torres.
That's my understanding.
We need to do that, Judge. We've got to do that.
Okay. My understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
The second expert is not likely to testify until Thursday. She's testifying in Bay County tomorrow. I will be here Thursday, and I spoke with Dr. Brandon last night. He will be present tomorrow morning as soon as he gets here from Coral Gables.
Did either Doctors Brannon or Harper rely on those medical records?
Dr. Harper did. It's in her deposition that was taken a couple of weeks ago. I think the question was posed.
Ms. Perez, good morning. If you're here for pretrial, 19 Alpha, Judge Myers is covering.
I went up there.
Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of George Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. She was asked by the state, attempt to introduce those records. We'll pare it down if we are.
Okay, you've got till 5 p.m. today to advise the state as to what of those culled down records you're going to be utilizing. So they have the opportunity to review those in advance of Dr. Harper testifying.
And I apologize to Madam Court Reporter for speaking on top of each other. Dr. Brandon is testifying as a subject matter expert who does not have specific familiarity with this case. And so there are no medical records or any other records that he has relied upon other than his knowledge and expertise.
Okay, all right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay, all right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers to review it, for us to discuss it, and to see whether or not it has merit or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Mr. Owens, at 9:38 last night. I'll give the opportunity to review that, and we can address it after the lunch hour. And that'll give the court the opportunity to do any research during the lunch hour on it as well. All right, anything else, Mr. J, that,
I'm not, I looked at it briefly, I'm not for sure exactly what the allegation is. I don't know if we need to talk about that, so there's, excuse me?
I'm not,
Can we approach the bench?
sure, come on up, yo. All right, thank you all very much. With regard to that motion, we're going to table that for now and address it potentially this afternoon. State is advised they're ready to proceed. Mr. Jay shook his head yes. Defense, you ready to proceed? Mr. Owens, you ready to proceed, sir?
Yes.
Thank you. All right. Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone be seated. Thank you. Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
You swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Again, could you state and spell your name for the record?
Yes. My name is Chelsea Kepsel, Chelsey, Koepsel.
All right. Mr. Cacciatore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene, is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving, is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who was your partner that day?
Detective Scott Lowen?
And throughout the whole time, you and Detective Lowen worked on this case together, is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including, like, deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Oh. Approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
All right, so that had already been done by the time that you arrived, is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses, is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone, is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it, is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement, is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it, is that correct?
Yes.
Okay. All right, so, and out there, that's part of talking to witnesses or potential witnesses. Okay, also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
All right, and in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right, and was Miss Melissa Roffengarden, is that how it's pronounced? Pronounce it for me.
Rough Garden.
Rothgarden, okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay, so were y'all walking around together? Give the jury an idea how that process takes place, please.
So yes, when I initially arrive on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures, and then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct, or pictures, or actually collect and take away. Is that correct?
Yes, that's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically. But that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes,
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
yes.
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that, is that correct?
Yes,
And also the stuff that you're learning outside of these items also helps you in making that determination, isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
All right. So out of the items that were collected at the house or the apartment, at those items, was anything, to your knowledge, sent off for further examination?
I believe so, but if it was, there would be, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time, there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone? Is that correct?
Yes.
In fact, that was done on her interview date, on would it have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of George Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA.
Oh, okay, yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay, who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it I would request it to the crime scene investigator, and she would, like, author the, I guess, like, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question
okay.
about it, okay? All right. But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done, okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres's autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
Okay. And did you communicate with the medical examiner at that time?
Yes, I did.
Okay. During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay, so after the autopsy, you had additional information, is that correct?
Yes, I did.
Okay. Now, there was an interview, well, I don't know if it was an interview, there was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is
Yeah.
that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification. And I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy. And then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving, we're going to make next of kin notification. She was very concerned about that, so I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone, is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry, did she give you permission to take the phone?
Yes.
Okay, is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone, is that correct?
No, it was based off of consent.
Okay, so she had consented to you to, for you to have her phone, is
Yes,
that correct? She also provided you the code to get in the phone, is that correct?
yes,
So at this point in time, Ms. Boone is cooperating with you, isn't that correct?
yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it, and those videos were found, I felt like this was very different, and it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be, basically, like, I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, you know, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until, I didn't submit it until the next day. And then it was signed the next day, on the 25th.
So basically, what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received, is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could go through I knew I could get a search warrant to go through the phone based off there being evidence, like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
Since they had explained to me that they spoke with family members the night prior, so I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented, and she could have not signed the paper consenting while we were on scene.
But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay. So, did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific, if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 25th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day, or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her or set up this meeting with her. Is that correct?
It's one or the other that
One
I'm.
or the other?
Yes.
Okay. As to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Is that correct?
it was a summary, yes.
All right, as far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to, not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, or they train you that your reports should be very much in detail. Is that correct?
Yes.
Okay? Because you might have to refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, and to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down, and where did y'all meet?
The Orange County Sheriff's Office Central Operations.
All right. To meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
Okay. Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am? Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at this time, at that time?
Yes, I was.
Okay. All right. Well, anyway, Ms. Boone, there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting.
She did.
On the 25th.
Yes.
That we saw. Okay. Now, ma'am, I'd like to talk to you about some other investigation. witnesses, other witnesses that you took their testimony or statements, recorded statements at different times, okay? Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Marino's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
All right, I would again object. She hasn't indicated that she needs assistance with her memory.
Approach. Objection sustained.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, Well, I just stated that it was either the 26th or 27th.
Okay, thank you. Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent, do you know his last name?
I would butcher it.
Me too, but Tagaloo, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then, did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Okay. Now, let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And, ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this for relevance.
Approach. Objection's overruled.
So ma'am, at that time, you did not tell Ms. Boone, prior to coming down there, that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
We plan to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her?
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, like physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Ms. Boone shows up, and you tell her there's some things that we need to talk about. Is that correct?
Specific verbiage, I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings, is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings, is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Ms. Boone wasn't under arrest, is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Ms. Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview?
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a reason, could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach. The objection is sustained.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, or let me specifically, in the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
May I confer, Judge?
Yes, sir.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
State, any other witnesses, evidence, or testimony to be produced?
Your Honor, at this time, the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address. So we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given to you over the last couple of days. Please do not discuss this case amongst yourselves or anyone else. Do not conduct any independent research or investigation as to the person, places, things, or charge involved in this case. And we'll bring you back in as promptly as possible. Thank you.
Jury exiting.
Gotta do some legal things.
You all may be seated. Thank you. Defense, any motions?
Judge, we do have some motions, but my client needs a comfort break.
Okay.
If we could do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you. We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Yes, sure, on behalf of the state, William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Lee.
Do we have any motions?
We do, Your Honor.
You may proceed.
If I may approach the podium, Your Honor.
Yes, sir.
Your Honor, at this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit. I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially has assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly of the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize, I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or an imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented testimony, an argument in this matter, not argument, but testimony that, in fact, George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that in fact that she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response?
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact, in taking all the facts in the light most favorable to the state and the inferences drawn from them, establish the elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Ms. Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m., 45 seconds, should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing, is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events. And therefore, we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement, both on the 24th and 25th, that I have no idea what happened. I just went to sleep, everything was good. And then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
All right, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last. Call whatever witnesses, put on exhibits, photographs, and then the client would be the last person to testify. Because of the nature of discharge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, and for the court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on, and based on that denial of that motion for judgment of acquittal, to just go through it again, because I know you're gonna ask to colloquy about all that. So, I'm gonna need a few moments with, I don't know, if it's 10 minutes maybe, for the 3 lawyers, 4 lawyers, to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you. We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Kester on behalf of the state. William J. for the state.
Defense?
James Owens from Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering in the affirmative. She's
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior incidents of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about that.
Okay, then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is, I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at the bag. And then the third thing is, that the state had filed that motion for the in-camera hearing. I don't know, maybe we need to hear that before she testifies?
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that George Torres committed on Sarah Boone, and there is a dispute about whether or not I have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence, or she took action to either block or physically restrain George Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that George Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose some of the acts that had been committed on her by George Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video, and so I think I can talk about the prior bad acts before the event in question chronologically, and I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020 before we go into reputation reputation evidence, prior instances of violence, or battered spouse syndrome evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence.
Any particular reason why it hasn't been done in the last 45 minutes?
Because
When I sent my jury out?
I've been meeting with my client about
Okay.
her rights to testify or not, and other related matters. So in terms of not giving her this evidence,
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment? It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits, and along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand back, bring it back in our panel.
Jury entering.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.